And now in our last webinar, we discussed empathy and aging. Today, we're going to be discussing wealth transfer. So before I introduce today's speaker, just be aware that we're going to mute and block participant video during the presentation, but we'll open it up at the end of the 30 to 40 minute presentation for Q&A. Courtney will help us with that. Please feel free to use the Q&A function in the Zoom app to submit questions. You could also use the chat function if you like, but there is a Q&A function in there for you. But today we're extremely lucky to again have Roberta Eckert of Nationwide's Retirement Institute. Roberta, she has close to 30 years experience in the financial industry and speaks to thousands of financial professionals every year. And she has a bio that is massive, and I'm not going to go through the whole thing today. But again, it's great that we have her here. We have a great relationship with Nationwide, and you know, I'm going to let Roberta's presentation speak for itself, and just let you go, Roberta. Thanks for being here.
Yeah, thanks, Glenn, and thanks everybody for taking the time out of your day to talk to us about bridging generations. And that is the third part of our three-part trilogy on Legacy Essentials. The Legacy Essentials program is one of the newer programs that we've created at the Nationwide Retirement Institute. And it's comprised of empathy, that's not the formal name, but sharpening your empathy skills. That's probably the only presentation out of our three-part series that really speaks to advisors and doesn't really translate very well over to a client presentation. But the other two do. And the second one was incorporated with our empathy presentation 2 weeks ago, and that is called Aging with Dignity. And how can you really work with your clients and understand or help them understand the risks that they face as they age? And that is something that with some modifications, we can deliver to clients as well. And the third is bridging generations. And again, we're going to provide the advisor and agent perspective today, but do know that this is also something that we can deliver to a group of clients or prospects. So with that, let's go ahead and get started. I'm going to turn my screen or my camera off because bandwidth sometimes gets a little cagey when I am delivering presentations, particularly from this lovely hotel room in beautiful Omaha, Nebraska, where I think is going to reach a high today of 19 degrees, but let's just say it's invigorating and kind of keeps you awake. So I'm going to go ahead and get my screen up for you, and we're going to talk about bridging generations. And there is going to be some content here that you are familiar with. Some maybe not so familiar with, but regardless of what it is, my objective is to give you some nuggets that you can start thinking about and really put on your either to-do list. I'm very reluctant to use the term New Year's resolutions, but things that maybe one or two or three, you want to make a real priority of going to your clients and making sure that they understand, number one, that you can, that you are aware of all of the impacts of their aging process, I guess. And the other one is to make sure that you've explained this to them pretty well. So I am seeing already we have a question. Can we receive a copy of the presentation? And the answer is sure. I'd be delighted to send you the deck when we're done. So first of all, one thing you want to know about all of the presentations we deliver at the Nationwide Retirement Institute is that this is educational only. And although we have got a whole lot of fantastic products that solve for a whole lot of needs, that's not what we're talking about today. We're also not talking about, I'm not giving you tax advice. I'm not giving you legal advice. We're just here to educate you. And so often you will see presentations that kind of blow right through this slide. I make a point of landing on it, particularly when I'm doing client events, because I want to make sure that clients know not to expect a product pitch at the end. Now, what we are going to be talking about are these couple of things and how you as a financial professional with hopefully some deep emotional connections to your clients to really take the lead in legacy planning. And then we're going to move over and talk about some of these concepts of legacy planning and how they're going to help meet specific goals your clients have, and in turn, something for you that will benefit your assets under management, and that is connecting to the next generation and helping them understand the real value that you have brought to their parent. So first of all, let's talk about, or start about talking about your role in legacy planning and why is it important to maybe broaden your scope a little bit. Now, as you're looking at this, you play a really important part in this legacy planning process. You're the linchpin, if you will. And part of the reason for that is that you know your client better than probably any of their other professionals. I would suggest that my financial advisor knows me better than my tax preparer or my attorney, not the least of which is I've known him for 20 years, and when I was wholesaling, I thought he was a great advisor, and so when it came time for me to choose one, I went right to him. But that's not common, of course, and again, you might know them better than any other professionals, and you can really leverage that knowledge to help fine-tune their goals. Really important, identify potential risks to those goals, and then of course frame solutions that you can tailor to those goals. Now, people sometimes, this might have been your experience, they're reluctant to engage in the estate planning process. Kind of like people are hesitant to buy life insurance. They're really apprehensive about confronting their own mortality. So this is where you can really be that trusted advisor by helping them understand why it's necessary, and more important, what happens in the absence of an estate plan. I always talk to, whenever I do presentations about this type of thing to clients, I will say, you don't have to raise your hand necessarily if you feel this is too personal of a question, but how many of you have an estate plan? And a lot of times people will raise their hand. And I'll start with saying, this was sort of a question. Everybody has an estate plan. The question is, or should be, are you in control of that plan, or have you left that estate planning process to the government to take it over for you? And so understanding the mechanics of transferring wealth, how clients can maintain that control over the process even after they're gone, and incorporating the beneficiaries into the planning process, I think are all real advantages to having these kinds of discussions. Now, these family members, they might be charged with important roles later, like executor or successor trustee. And one other thing that you want to tap into is understanding the client's family dynamic. And once you do that, that's going to go a long way towards helping this process. The goals of the plan are listed right here, and a legacy plan is going to have a lot of goals, not the least of which is transferring wealth. Probably the most obvious, but it's going to reflect the client's objectives as to who's going to get what. And very frequently, it's more than just money. You dig a little deeper, you find that there are family dynamics at play. There are historical or elements that come into play, based on what someone has learned either overtly or subconsciously from parents or grandparents transferring wealth. A good legacy plan is going to address items with sentimental and emotional value also. Like who's getting mom's diamond engagement ring? Who's going to get the family photos? This can also help minimize conflict against beneficiaries. So let's talk about taxes for a moment. That is a major consideration in any wealth transfer plan. And a lot of people equate estate planning with estate taxes. That's understandable, but income taxes are often going to be a bigger issue. So that's a huge opportunity for you as the financial professional, because developing strategies to minimize income taxes requires not just a clear understanding of the client's financial situation, but also the beneficiary's financial situation. So the earlier you can start working and getting to know those beneficiaries, the greater the likelihood of retaining them as clients. Also, there are clients that are going to have vulnerable beneficiaries. Some might lack the maturity or even the age to manage a large inheritance. What if a beneficiary is 12 years old? Some might have behavioral or financial issues that might need to be addressed. Maybe there's some disability issues that would leave them unable to manage their own affairs. So a really concrete, airtight legacy plan is going to take all that under advisement as well. And then what about charitable causes? There are charitable causes that are going to, matter to your beneficiaries. They're going to be often priorities for many affluent clients. And again, that's where you can involve beneficiaries as well. What about a business and succession planning? A lot of times clients, if they own a business, have much of their wealth invested in that business or even a family farm. So how does that asset transition to the next generation? And of course, that's going to require some pretty careful planning as well. And if you are not an expert in succession planning, fear not. You can still coordinate with other specialists. We've got some at Nationwide, public service announcement there, to develop and execute a strategy that's really going to help meet those objectives. So your role as a financial professional in this whole process is to have a good understanding of the tools at your disposal, like estate planning, like beneficiary designations, and then also identify the situation in which they're needed. At the risk of sounding too simplistic, I've got a hammer in my toolbox, but I'm not going to use that to screw a screw into a piece of wood. You know, I need to identify that, oh yes, the hammer is used to hammer nails into something. So in this next section, we're going to talk about translating those tools into real life scenarios. But as we get started, we're going to do a little bit of a review, and there might be some language or nomenclature here that you can utilize when you're starting to have, starting to address and broach this topic with your clients. So what's estate planning? Well, very simply put, it's the preparation for distribution and management of someone's assets at death. The tools you use are wills, trusts, and other arrangements. And the objective is to reduce administrative costs and transfer tax liabilities while still making sure that your client's wishes are carried out and that they are respected. So why do I need a will? I'll tell you a story that happened to me about 8 or 10 years ago. I was doing some consulting work with a major broker-dealer firm that you absolutely would recognize if I named the name, but I'm not going to. And one of the partnerships in the firm consisted of a very successful gentleman who I'd known for years, and his son, and the son's an only child. The son in turn had 2 children, so it was the grandchild of the kind of initial partner, I guess, in this relationship, the grandfather. And it came to be known that the son, the father of the 2 young children, did not have a will. And as we were talking to several clients about wills and things like this, it came out that this young man, who wasn't that young, he was maybe 35 years old, did not have a will. And these folks in the room just recoiled. And in fact, one of them actually left the practice. Now, I don't know if that was the deciding factor, but boy, you know, how can you advise people on all this if you yourself have not made your estate plan buttoned down? So for many people, this is the primary estate planning document. And if anybody asks you, why do you need a will? Well, I think the question that you want to flip around to them is, what happens if you don't have one? And in that case, your property is going to pass through your state's intestacy statute. That's what I was talking about when earlier I said, you've got an estate plan. Well, the question becomes, are you in control of it? And is it going to be a document and a tool that carries out your wishes? Or are you going to let the state take care of that? So these laws are going to typically lay out rigid rules if you die intestate about how your estate's going to be divided. An administrator is going to be appointed, not your choice, to supervise the distribution of assets. And the bottom line is that if you die intestate, you might not reflect your distribution or your wishes for the distribution of your assets. Now, you might know this, wills do not avoid probate. Probate is simply the court's supervised distribution of the estate, and the will is just going to provide the court with a roadmap or instructions on that distribution. One thing to consider about probate is that it is a public process. And if someone wants to avoid probate, they might want to consider a trust as an alternative to a will. And we'll look at that in just a second. So what's covered by a will? Well, you can see it right there. All personal property, but kind of highlight this last section of words, that does not pass by other means. So it could be something like a vacation home or regular home, something as small as I mentioned earlier as family photos. And I know when I put my will together, our attorney said, what you want to do is write up a list of all the kind of bits and pieces in your home, the family photos, the jewelry, the oil painting, whatever it is that you want to outline who gets what. It's also important to understand what doesn't pass pursuant to your will, like retirement accounts, like annuities and life insurance and jointly owned financial accounts and real estate. Typically that falls to the joint owner on the account. So not everything's covered by a will, and it might surprise some of your clients to realize that. One benefit of a will is that you can name an executor. Sometimes it's called a personal representative, and this is somebody who's responsible for carrying out the terms of the will. I mentioned on our legacy planning discussion 2 weeks ago that when my parents crafted their will, the individual that they selected as the executor of that estate was my brother. He is 12 years older than I am. He was a civil engineer. By contrast, I'd been in financial services my entire career. And one day I went to my parents and said, you know, my brother doesn't know anything about this stuff. And moreover, without spilling too much family dirt, he was married to a woman who together saw my parents as kind of an open checkbook. My parents started to realize this, and they made me co-executrix of the will, which came in very handy when they ultimately passed away and it came time for the distribution of assets. So the executor also needs to be responsible for maintaining assets, winding down the affairs. It doesn't necessarily need to be a family member. You want to consider temperament of someone that you're selecting to be the executor. They have to carry out the client's intent, and they've got to deal with all the beneficiaries. Now, as I mentioned earlier, in my particular situation, my parents could name multiple executors or independent executors. But something else about a will, and that can be used to name a guardian for minor children. My daughter has 2 small children, and that is absolutely front and center for them as they put together their own will. And it's super important because without clear instructions, custody over minor children could lead to some real nasty conflict within the family. So I mentioned a letter of instruction. I won't belabor that point, but there are some things that your clients might want to bequeath or make sure someone else has. I've got a particular piece of needlework that my daughter-in-law just loves at Christmas. It wasn't expensive. I created it myself, but she just raves over it every time. And I said, not to worry. I'll put a little piece of masking tape on the back of it that says it's yours. But things like collectibles, art, now some of these things might have some significant value as opposed to just sentimental value. And that might be something that's considered when it comes time to valuing the estate. But at the same time, you are certainly, regardless of the value, okay, isolating those particular assets and personal property, calling them out by name and indicating who gets what. So wills are pretty important estate planning tools, but they do have limitations. And as I mentioned earlier, they do not avoid the expense, publicity, and the delay of probate. So a will isn't going to offer ongoing control over distribution of assets. The executor is going to try and distribute those assets and settle the estate as quickly as possible because there's going to be an estate tax return due 9 months after the passing away of the individual. So once the beneficiaries of the will receive the assets, that's it, end of story, and they're free to do with them what they please. So in a lot of cases, a will alone might not be sufficient to meet your client's objectives. And that's really true if your client wants to plan for different contingencies or protect beneficiaries from inheriting a large amount of wealth all at once. And so that brings us to another tool, which is a trust. Now, these are estate planning tools that offer a lot of advantages over a simple will. And in this case, they can help clients avoid probate and maintain privacy. Also, for something like, well, I'll get to that in a minute. I'm thinking about being able to carve out some assets and leave them to maybe another child or someone else without the rest of the beneficiaries being aware of that. We'll talk about that later. But a trust can also provide for a successor trustee, and that's an ongoing job because that person's going to manage trust assets if necessary. Most importantly, though, a trust can provide a client with control over how assets are going to be distributed in the future. And there are a few scenarios in which this can be an important thing to consider. So, for example, if a client wants to avoid the probate process, or if they seek to control the distribution of assets over time, they might want to consider looking at how a trust might be a suitable tool. So there are a lot of trusts. Of course, there are attorneys that can draft trusts to meet a variety of client objectives. But you know, as a financial professional, you want to be familiar with two concepts. One is revocable or living trust. Sometimes it's called a grantor trust. And the irrevocable trust, or sometimes called a non-grantor trust. And we'll start by talking about the living trust. So a really easy way, I think, to explain a revocable trust to your clients is that this is an alternative to a will. So unlike a will, a living trust is going to avoid probate. So it's not a matter of public record. When you pass away, your next door neighbors, your snoopy next door neighbor isn't going to keep looking up the court documents and find out how much was left to whom and all that sort of thing. It also protects privacy. So here's how it works. I can execute a living trust while I'm alive. I name myself as the trustee. I also name a successor trustee, and that's the person who's going to manage the trust if I can. What makes this living trust a bit different than a will is that it doesn't automatically cover all of my property. In order for my living trust to be effective, I have to fund it. It can't just be a shell with nothing in it. That means I have to transfer ownership of the assets that I want the trust to control. So let's imagine I have a brokerage account and I want the trust to control it after my death. I have to make my trust owner of that account before I die. And it can be a simple matter as just changing the owner of the account to, for example, Roberta Eckert, Revocable Trust, dated, what's today? 1/26/22. So because that trust remains revocable during my lifetime, I can move property in and out of the trust whenever I want, and I can also revoke it, get it, or cancel the trust if I want to. So a couple other things about this. Another characteristic is that while the grantor, the person who sets up and funds the trust, that's me, is alive, the trust is usually going to use the owner's social security number for taxes. That's me. So any trust received by the trust, any income received by the trust, it's going to be taxable to me. A revocable living trust is also going to be included in my estate. Now, I want to make sure and take care to name a successor trustee. And that trustee is going to be able to manage the trust assets in the event I'm not able to do it. That can make a living trust a very useful alternative to a POA or power of attorney. We talked about that in the aging section for finances. So if I become incapacitated, my successor trustee can step in and manage those assets. Now, once I pass away, the revocable living trust becomes an irrevocable trust. And any property that was held is now going to be considered owned by the now irrevocable trust. So hopefully this isn't getting too deep in the weeds, but that new trustee, the successor trustee, is going to have to obtain a tax ID for the trust, and it's going to be considered a separate legal entity from the grantor, or that's me, or my estate. It's even going to have to file its own tax returns. So the key feature of the irrevocable trust, it's a separate legal entity from me, the person who set it up. It's going to have its own tax ID. It's going to file a trust tax return each year. And if it's set up correctly, that's why it's always a great idea to set up a strategic relationship or alliance with an estate attorney. But when it's set up correctly, an irrevocable trust is generally not included in my estate when I pass away. But any taxes on income the irrevocable trust generates can be significant. You'll look at some numbers that I'll share with you in just a couple of moments. But what's the reason for that? Well, the reason is tax law, or pardon me, the reason for this specific tax law is because it's meant to discourage people from using irrevocable trust as a wealth accumulation vehicle. So an irrevocable trust can be funded at death or while I'm still alive. But once I set up this separate legal entity, transfers assets to the trust is considered a gift. And we'll look at that in just a couple of moments. So a couple of common types of irrevocable trusts. One is marital. There's a credit shelter trust, special needs, an ILET, or a charitable trust. And we've got a group that works side by side with our team at the Nationwide Retirement Institute. It's called the Advanced Consulting Group, and that team can walk you through all the nuts and bolts and get much deeper in the weeds on how each one really works and what it's intended to do. But what I promised was to talk to you a little bit about taxes. And one thing everybody needs to know is that irrevocable trusts have a different kind of tax treatment. So when a trust has income, it can do one of two things: pay it out to a beneficiary or retain it. Now, when a trust pays income to a beneficiary, this kind of makes some sense. The beneficiary has to pay taxes on the income. So when a trust retains the income, keeps its proverbial or hypothetical hands on it, then the trust itself has to pay taxes on the income. Either way, taxes are going to get paid on that income. So the IRS wanted to discourage trusts from retaining large amounts of income, so they tax these trusts pretty aggressively. And the tax brackets for trusts are compressed. It's going to get to a 37% bracket for ordinary income at just $13,000 of taxable income. When you consider what that is on an individual basis, to get to the 37% tax bracket, you need to have some significant taxable income as an individual. With the trust, though, it reaches the 20% bracket on long-term capital gains and dividends at just $13,150 of taxable income. Now, I mentioned the individual rates. I'm not going to get to that 37% income tax bracket as my own individual taxpayer or tax status until I hit over $500,000 in taxable income. So obviously, tax efficiency, pretty critical when managing these assets. So what could you put in a trust to minimize or mitigate some taxes? Well, tax-free municipal bonds, low portfolio turnover or low turnover portfolios, maybe a deferred annuity. So if a trust owns an annuity, then the trust is going to maintain the tax preferred or tax deferred status of that annuity. So when you're looking at beneficiaries, there we go. A couple of designations that I see year over year over year, people bungle this. So at the very least, doing a beneficiary review, especially now that it's at the beginning of the year, everybody's trying to organize and declutter and straighten up. All you have to do is stand in the checkout line at the grocery store, and you'll see every single magazine talks about simplifying your life, declutter things, clean all that junk out of your office. And certainly nowhere is that more important than looking at beneficiaries and making sure that that is cleaned up. So engaging your clients on estate planning opens a lot of great conversations. And as I mentioned earlier, can also create opportunities to involve the family in the planning process. So beneficiaries designations, and for many clients, these beneficiary designations will conceivably transfer more of their wealth than any other planning document. Why is that? Because most people carry most of their wealth in retirement plans, IRAs, 401ks, retirement plans, and so forth. So a lot of different types of financial accounts have, of course, beneficiary designations. You know this, including IRAs, retirement accounts, and so forth. And one thing about these accounts is that they are often chock full of taxable income. And this is sometimes referred to IRD, or income in respect of a decedent. Taxes on that income are generally going to be paid by the beneficiaries. So the designation can also have some really important and serious tax implications. The good news, life insurance, those death benefits are typically tax-free, and that simplifies the beneficiary designation process when you're looking at life insurance. Here are the mistakes we see. I'm not going to go through each one of them. You will get a copy of the deck on these slides, but certainly one thing that I see that's not listed here is in the event of a remarriage, leaving the former spouse as the beneficiary on separate policies. So if you have any clients that have recently married or remarried, be sure, especially if they've been divorced, do be sure that the beneficiary designations have been updated. So one other thing is that currently the stretch payout option remains available for non-qualified annuity contracts, and restrictions can be placed on beneficiaries of annuity contracts to meet certain distribution goals. That's also true of life insurance policies. So this is sometimes called control from the grave. You might want to create or have your client create an annuity distribution that's maybe paid out over time. There are lots of different choices there, but they does not have to be paid all at once. So when we're looking at all of this, the really important thing is, how can we translate this into real life instead of just sounding like an estate attorney and sounding like you're studying for the estate bar exam? I don't know that there is such a thing, but you get the idea. Our goal today is to help you recognize when and how you can use these tools to help your clients accomplish their wealth transfer goals. Obviously, people are going to have many different objectives for many different beneficiaries, and there's some unique considerations for each. So we're going to review a couple scenarios and consider real life applications of some of these estate planning tools for the next 5-10 minutes or so. All right, so first of all, spousal beneficiaries. For many clients, protecting a surviving spouse is going to be one of the top of the list when it comes to legacy planning concerns. So some situations are going to require extra considerations. Significantly older or younger spouses and community property statutes can create some planning issues. So a retirement account owner whose spouse is, for example, more than 10 years younger than they are, gets to use a different distribution table. What does that mean? It means smaller RMDs. Then, if the younger spouse inherits the retirement account, they can always transfer it into their own name. But what if they're not yet 59 and a half? What if they were 57 and their 80-year-old spouse passed away? If they're not yet 59 and need money from the account, what happens then? Well, leaving the account title as an inherited IRA would provide the surviving spouse with an exception to that 10% penalty on pre-59 and a half withdrawals. And something else to think about, if the surviving spouse is the older of the two, if the deceased spouse was not yet at their start date for RMDs, but the surviving spouse is over 72, that surviving spouse can leave an inherited IRA in the name of the deceased, read younger spouse, to delay RMDs. Another beneficiary issue for spouses, community property states. There are 9 states in which each spouse is generally considered to have a 50% interest in all property accumulated during the marriage. And those rules might give a surviving spouse a claim to retirement assets regardless of a conflicting beneficiary designation. So be aware whether you are in a community property state, Glenn, That's you because you live in Texas. One other thing is second marriages. I mentioned that when we were looking at beneficiaries, but they could also add complexity. They require a thorough understanding of the relationship, not only between spouses, but what about spouses and any children of prior marriages? So what does a Q-tip do? Well, a qualifying terminable interest property, it's a type of marital trust, and that's often used when a decedent has children from a prior marriage. A Q-tip trust is going to put limits on the surviving spouse's ability to invade trust principle, preserving more assets for the remainder beneficiaries. Let's say my husband has children from a former marriage, he and I get married, I have no children, he leaves everything to me with no limits. Then I'm on my Caribbean cruise where I am going to get over my grief from losing my spouse. I fall in love with the cabin boy. We get married, and now the cabin boy has control over all of the assets, and his children from the first marriage are cut out. So obviously a Q-tip can help with that, and so do beneficiary designations. But one thing that's overlooked from time to time is the income plan for the surviving spouse. Of course, whereas 2 Social Security checks were probably coming into the household, now there's just 1. Now, we say all the time, of course, that your income needs don't get cut in half when somebody dies. You're not going to live on half of that income. You still need to turn the lights on in the living room, whether there's 1 person sitting in the living room or 16 people sitting in the living room. But also something that we talk about in our tax-efficient retirement income program is the widow's penalty. So here's the high level of this, and we can talk more about this too. But for couples with a large RMD, a surviving spouse can really end up in a tough tax situation. Here's how it works. When spouses leave all of their retirement assets to each other, the RMD for the surviving spouse might not change much when the first spouse dies. You still have both of those RMDs coming into the household. But what will change is the tax filing status of the survivor. When I go from joint filing to a single filer, the survivor, that's me, is going to have a smaller standard deduction, and I'm also going to be subject to individual tax brackets, which are narrower and more compressed than those for married filers. So think about it. I'm getting the same amount of RMD coming in, but I'm taxed at a higher rate. And also my standard deduction is smaller. So I can find myself exposed to higher marginal and effective tax rates. So how do you plan for that? Well, you can implement a retirement income plan that minimizes future RMDs for a surviving spouse. Maybe start taking the RMDs sooner than you thought you might, and delay Social Security, for example. What about adult children and other non-spouse beneficiaries? And I'm sure you've heard all kinds of stories about all of this. Adult children doesn't always mean that they have adult behavior, and knowing those beneficiaries is really important. Get to know them a little bit. Don't just rely on what your client's saying about them. See for yourself. It's really critical to fully understand each beneficiary's needs and circumstances, both good and bad. For example, affluent clients tend to have affluent kids. And I was just reading an article about this about 3 months ago, and that is that people typically want to have their children have a better life than they did. They don't want their kids to have to work as hard as they did or struggle as much. And consequently, when it comes time to craft an estate plan, the parents kind of then turn things over a little bit or turn around and say, well, wait a minute, this kid doesn't have a great work ethic. I worked really hard and they're not working as hard as I did. So I don't know that I want to leave them so much money. So it kind of is the reverse sentiment of what happened when they were raising these children. But it's certainly something to consider. If your client's got a really successful kid that's in a high tax bracket, you need to know that. It's going to have an impact on what assets the parent might choose to leave to the child. That child also might need your help in implementing a tax-efficient distribution for inherited assets. And then there are beneficiaries at the other end of the financial spectrum. What about kids who can't manage money, behavioral issues, but just don't have that financial acumen? That's where trust planning can come into play as well. So we want to think about leaving assets to non-spouse beneficiaries. And as we've discussed, trust might be needed to control distribution or protect the inheritance of maybe some special needs beneficiaries. And earlier I mentioned the elimination of the stretch option, and that brings us really to consider how Roth IRA planning can come into play when leaving assets to adult children. There's certainly something to consider. Roth accounts might be suitable wealth transfer tools. If I've got existing Roth accounts, I might want to earmark those for a beneficiary who's in a high marginal tax bracket, because they're still going to be faced with the 10-year distribution period, but the distributions are going to be tax-free. What about grandchildren? Well, if you recall our slide about potential mistakes when designating beneficiaries, one of them was naming a minor as a potential mistake. That's because minors don't have legal capacity to manage financial assets, and an adult often has to be appointed as a guardian. That can involve some time and expense. So Uniform Transfers to Minors Act, or a UTMA, might have some planning capabilities that would allow you to name a custodian to manage the assets until the grandchild reaches age of majority. Now, one thing about UTMA accounts, once the beneficiary attains the age of majority, they are going to have unlimited access to the asset. If they want to buy the Ferrari, they're going to be able to buy the Ferrari, and you have no control from the grave over that. Don't overlook 529 plans either. That might be one way of kind of getting around that. Also, there's some charitable giving options. Gifting highly appreciated assets can help your client avoid capital gains tax liability while also providing them with an income tax deduction. If you have clients over 70 and a half, making a qualified charitable distribution directly from an IRA can satisfy the RMD requirement, provide that gift to charity, and doesn't add to the annual tax bill. So if the client's starting to take RMDs, they can direct that money directly to the charity. They wouldn't get the charitable deduction by doing that. But what they are going to do is, instead of taking the RMD and having it be part of their taxable income, it actually lowers the amount of taxable income for that particular year. For our purposes today, we're not going to get deep in the weeds about a CRT or a charitable remainder trust. Again, that is something where our advanced consulting group can walk through that with you, but know that there are a lot of strategies that are available there. And what about when a business is part of a legacy? Well, that's something else that's something that really needs to be considered in succession planning. And we've got a group at Nationwide, so get ready for the public service announcement. It's called Land as Your Legacy. And although we started out working in the agricultural business about how do farmers transfer that giant asset to their children, it's really now been broadened to encompass any kind of large, I want to say illiquid type of estate. So this could be a business. Our team there on Land as Your Legacy provides consultation and strategies around risk management, financial independence, estate planning. But it was created to help hundreds of farm families utilize a comprehensive transition plan, and it can help you as well. So a couple takeaways. I've probably already turned the fire hose on you in estate planning information, but why is it important to your practice? I never want to leave any kind of discussion without thinking about you. On one of our most recent presentations, we mentioned 2 weeks ago that 87% of affluent investors chose not to work with their parents' financial professional. And when we pressed a little, or when Cerulli pressed a little further about that, 88% of that group said, we never even considered it. Many of those surveyed told us the one reason was that their parents' financial professional never attempted to build a relationship with them. So how do you do that? Ask for introductions. I've got a best practice from a financial professional I've known for years. And sometime around Thanksgiving or the Christmas holidays, he says, when are you kids coming into town? like to take you all to lunch. And so that way he gets to meet the beneficiaries in a social setting. If the topics turn to financial strategies, estate planning, and so forth, so be it. But it's a great way to start to get to know those ultimate beneficiaries without having it be purely business all the time. Subsequently, you can arrange meetings and show them what you've done so far, not just to help the parents with their legacy planning, but also to protect them as the beneficiary from undue taxes, for example. So as we wrap up the third part of our legacy planning series, remember that empathy really is the linchpin and the key to all of this. And we talked in the first section about legacy, or about empathy being really a muscle that you can exercise and get stronger. And nobody really cares about how empathetic you are unless your clients really get the idea that you are in fact empathetic. Then that helps to open the doors towards discussions around aging and the financial risks that are, financial, physical, cognitive risks that come along with the aging process. And then also having those really important discussions about legacy planning, which can put you in the center of the client's world and help you retain and grow your business. So I'm going to leave this up here. If you would like more information, you can get on our site. The site there is nationwidefinancial.com/legacy essentials. You can call our advanced consulting group. And as promised, I'm going to give Glenn a copy of this particular deck that he can forward to all of you on the call. So thanks so much for attending our presentation today. And with that, I'm going to turn it over to Glenn, I guess, see what kind of questions we might have, and take it from there.
Thank you so much, Roberta. Good stuff. I loved it.